Okay, let's unpack this. Welcome everyone to a deep dive.
Great to be here.
We're digging into something quite specific today. It's a recent legal filing. Comes from a civil case, Haltom v. City of Henderson TN Police Department.
Right, but the source material we looked at, this constitutional analysis report, it really uses that one filing as a launch pad.
Yeah, it does. It connects this single court document to some really big ideas, foundational American principles, history.
Mentions the Pilgrims' journey.
Right, and key legal concepts, even, broader themes of national renewal. It's quite a web.
So our job here really is to sort through all that and pull out the key insights for you. We want to show how something that looks purely technical on the surface,
Like a court filing.
exactly, how it can actually connect to these deeper historical and philosophical threads woven into American law. At least that's the argument in the report we reviewed.
Okay, sounds good. So following that thread then, where does the source say this specific case filing actually starts? What's the immediate context?
Well, begins with the plaintiff, Joshua Haltom. He's representing himself in court, a pro se litigant.
Okay.
And he filed this document called a notice to the court. Basically, it's him raising concerns about how the defense is acting in the lawsuit.
And what's his main point in this notice? What's he arguing?
According to the analysis we read, Haltom is saying the defense is kind of ignoring the facts already established in the case.
Ignoring the record.
Yeah, and maybe downplaying the seriousness of the alleged misconduct that the lawsuit is actually about. He seems to feel the core facts he's presented are already, quote, conclusively established.
Interesting. So he's really challenging their whole approach. What legal tools does the analysis highlight him using to make this point?
Well, the report specifically notes he's bringing up certain federal rules of civil procedure. The first one mentioned is Rule 11.
Rule 11. Okay, what's that about?
That rule essentially requires that anything filed in court needs to be, based on evidence, factually sound, and not filed for some improper purpose like harassment or delay.
Got it. So good faith and factual basis.
Exactly. Haltom is suggesting the defense's position might not square with that standard.
Okay. What else?
He also references Rule 56. That's the rule governing summary judgment.
Right, where a judge can decide a case early if there's no real fight over the important facts.
Precisely. So by saying the facts are conclusively established, Haltom's kind of warning them, implying that their stance might not hold up if it gets to summary judgment, because in his view, there's no genuine factual dispute left.
And there was something else mentioned too, a Supreme Court case.
Yeah, the source says he referenced the idea from Chambers v. Nasco, Inc. That case confirms courts have this sort of inherent power to sanction bad faith conduct.
But he wasn't actually asking for sanctions.
Not yet, no. The report is clear on that. He specifically said he wasn't seeking sanctions at this juncture. It's more like flagging the issue.
The source makes a point that it's kind of striking for someone representing themselves to be using these specific, fairly sophisticated procedural arguments.
It does. It suggests maybe a deeper level of legal engagement than you might sometimes assume with pro se litigants who sometimes struggle with procedural stuff.
Right. And this is where the analysis really pivots, doesn't it? From this specific procedural move.
Yeah, it zooms way out. The report connects this whole situation back to the historical roots of liberty, specifically looking at the Pilgrims.
Who most people just think of as fleeing religious persecution in England.
Which they were, definitely. But the report adds another layer, highlighting they also left Holland partly because of great labor and hardfare, economic hardship.
So it wasn't just about belief.
Well, it was connected. They needed greater economic opportunity, partly to actually sustain their religious community and their whole way of life. So it wasn't just freedom from something, but freedom to actively build and maintain their society on their own terms.
And that drive, that freedom to build, not just escape, that surely influenced the founders later on, especially when they thought about church and state.
Absolutely. The source connects that directly to the thinking behind the First Amendment's Establishment Clause. The goal wasn't just preventing an official government church.
Like in England.
Right, but also protecting genuine religious liberty for everyone, especially minority faiths, and keeping a government from, politically controlling religion. It's kind of a two-way street, that separation, Jefferson's wall, Madison's arguments. It's all tied in.
The analysis also brought up another distinction I thought was really interesting. The difference between lawful and legal.
Ah, yes. That's a key concept the source explores. Legal, in this view, is about sticking to the written laws, the codes, the statutes. It's the formal side.
The letter of the law?
Pretty much. But lawful, as presented in the analysis, is wider. It implies sticking to the substance of law, maybe a higher principle, natural justice, something like that.
Yeah.
Even if an action isn't strictly legal according to the current rules.
So something could be lawful in spirit, even if technically illegal.
That's the idea the source puts forward. It uses the Pilgrims. Again, defying English law based on their conscience could be seen as lawful in their own framework, even though the Crown obviously saw it as illegal.
Okay, bringing it back to Haltom's case today. When he's in court, who actually makes the law that the judge applies? Is it the judge?
That's a really important point of clarification. No, judges don't make the law in that sense. The legislative branch, Congress, at the federal level, enacts the statutes.
Okay.
And the executive branch makes regulations under those statutes. The judicial branch, the courts, their job is to apply and interpret those existing laws.
The statutes, the rules like FRCP 11 and 56 we talked about.
Exactly. And also previous court decisions, what we call precedent.
Yeah.
They apply all that to the specific facts of the case before them to make a decision. That process is called adjudication.
Got it. Now, the source analysis got pretty expansive towards the end. It even floated this, well, speculative question. Could U.S. courts actually trigger a second American Renaissance?
Yeah, it went there. But the analysis itself sort of answers its own question. It acknowledges courts are fundamentally reactive. They deal with the specific cases and legal questions brought to them.
They don't just decide to start a renaissance.
Right. They interpret and apply the law.
Yeah.
Now, landmark decisions can have huge societal impacts over time. They can catalyze change. The source mentions civil rights cases as an example. But courts operate within their defined role. They don't generally initiate broad social movements on their own.
And the analysis also weaves in some broader themes about renewal, doesn't it? Things that seem to resonate with Haltom's own perspective mentioned elsewhere in the source.
It does. It briefly touches on a biblical reference from Zechariah 3, the image of Joshua the high priest being cleansed, getting new garments. The source uses this kind of metaphorically.
How so?
As reflecting themes of judgment, cleansing, transformation.
Oh.
Which the report suggests echo in Haltom's pursuit of accountability in his lawsuit. And the report also just factually mentions other ideas. Haltom is apparently expressed elsewhere. Concepts like Nazara, which is about economic reform, the 1776 Commission's focus on founding principles, a call for a jubilee year of cleansing or resetting things, and using article via the Constitution for amendments.
So presenting those as part of his broader vision for national renewal, which the analysis connects back to the case themes.
Exactly. The report presents them neutrally as part of the context surrounding his views, linking it all back to the core themes it identified.
Wow. Okay, so we really did travel quite a distance there. From one specific court filing,
A notice to the court.
all the way through the Pilgrims, the Constitution, how courts actually work, and into these much larger ideas about national change and even spiritual metaphors, all mapped out in that one analysis report.
It's quite a journey. And it highlights how even the seemingly dry procedural aspects of law, like upholding rules and interpreting statutes, are part of that continuous, often slow pursuit of justice within our system.
Absolutely. So maybe a final thought for you listening. Consider how that tension the source raised between the lawful, what feels fundamentally right or adheres to a higher principle, and the legal, what's actually written down in the law books, how that tension keeps playing out. It shapes so much of our understanding of justice and liberty in America, right down to the arguments made in courtrooms every day.